Okay, good morning. I think they asked me on to this program to break up the monotony of responsible discourse. And I'll try. I think many of the mistakes, the errors, the sins, however you'd like to refer to them, that we're discussing relate back to some basic precursor problems that very often, if brought into focus, would put some perspective to the evaluation process. I think evaluators very often lose sight of the nature, the scope, and the limitations of the discipline of psychology. And from that lack of focus, a lot of these other errors flow. Psychology in any university Psych 101 course book, page 1, you're going to find either verbatim or very close to this statement that psychology is the scientific study of behavior and mental processes. And if you take out the word scientific, you no longer have psychology, you have philosophy. And there's nothing wrong with philosophical speculation, but we don't allow that from the witness stand. The fact that you're allowed in, put on the witness stand, is because of certain defined rules that your discipline hopefully meets that allow expert testimony to be given. Very good book, by the way, especially for the lawyers in the room to get some insight into critical thinking about the psychology discipline, is this one, How to Think Straight About Psychology. And he talks about the fact the only coherence that psychology as a discipline has lies in its commitment to science and the scientific method. He said the only two things that justify the existence of psychology as apart from philosophy is that it studies the range of human behavior with the techniques of science, and the knowledge of the profession is scientifically based. And that psychology gives two guarantees to the public. Right? One, the conclusions that psychologists express about behavior will be produced from scientific evidence. And also that no statements or conclusions will be expressed that are not derived from scientific evidence that was derived from tested scientific methods. That is the core value of the discipline of psychology, to ensure the reliability of the statements that psychologists make. In the year 2000, a view from the bench, a judge in California wrote an open letter to the psychology profession based on his observations in seeing the testimony. Your profession has strong roots as a discipline with a foundation in the scientific method. The problem is that some of you have stopped using it. And many of the mistakes and errors that David and Jeff have talked about, and some that I'll highlight shortly, flow from the fact that I think too often evaluators get out there, they're struggling to make this discipline accomplish the missions that are assigned, instead of asking, does this mission really fully fall within the ambit of my discipline? The best interest of the child, that ultimate, final, decisive question, is not entirely a good fit with the psychology discipline, and to a very significant degree falls beyond the boundaries of the limitations of the field, because it's a legal concept, and because there's no matching empirically derived construct in the psychology field that matches this amorphous concept that the law is attempting to describe by using the term best interest of the child. Nowhere is it operationally defined, not either by the behavioral science field nor by law. It is laden with value judgments that have to be made that fall outside the boundaries of any professional discipline. Right? Outcome subjectivity, variable subjectivity. These are the problems that the law, in effect, dumps upon the evaluator in asking the evaluator to come up with the magic answers that are going to make the court's job easy. Okay? No defined outcome criteria. Best interest of the child, indeterminate, value-laden standard. let's just do a little thought process here. Something happened on that. Outcome A, outcome B. Let's suspend reality for a moment and assume we can do something. We can perfectly predict that if we give the child to parent A, this will be the outcome for the child. Parent B, that will be the outcome, right? If we give the child to parent A, the child is going to barely make it through high school. College will be out of the question. He will never hold a steady job, right? But like Alfred E. Newman from Mad Magazine, he will never have a single moment of stress. He will be happy as a pig in slop. Me, worry, no. As long as I've got the remote and the Cheeto crumbs falling all over me, life is good. That's parent A. On the other hand, if we give the child to parent B, the child will perform at the highest possible academic level through undergraduate education, go on to postgraduate or professional education, and will go on to the top of his career with all of the professional and material success that goes with that. But of course, as some of us know, we'll pay a price for that. The occasional Xanax will be necessary to get us through the goddamn day, all right? But it all goes with the territory, all right? Here's the question. How many say, knowing those two possible outcomes, let's give the kid to parent A? How many say A? May I see your hands, please? May I see your hands? All right. How many say B? All right. And most of you are not voting. And I'll say this to you. I'm sure the ones who said parent A are mental health professionals, and the ones who said parent B are the lawyers who said, get those bucks, pop those pills. But now let's change it a little bit. How many of you said you go with outcome A? Let me see your hands again. All right? So you take that stress-free, carefree life in lieu of money. Let me just change the fact one little bit. Outcome A is the same. Outcome B, high success, only it's not money. He'll discover a cure for cancer that will wipe that disease from the face of the earth. How many of you who said outcome A was better would now say outcome B? All right, a couple. Here's the point of all of this. No matter how you voted, nobody's going to walk through that door with empirical research or law that's going to prove you wrong, because you exercised judgments on values. And every time a judge decides best interest, the judge is making value judgments, if not explicitly, certainly implicitly. Variable subjectivity. Some states, many states have statutes that delineate the factors. Other states, like New York, the common law, you derive them from the case law. All kinds of factors to be considered. But nobody tells us how to weight them. All right? One factor, which parent best contributes to the intellectual development of the child? Another factor, which one better contributes to the emotional development? Two different factors. One is parent A and the other is parent B. Should one weigh more than the other? And if so, which one? Or should they be weighted equally? No guidance. So we wonder why evaluators are kind of floundering at times. They're trying in many ways to put a square peg into a round hole. One judge succinctly said, bottom line, what's in the child's best interest equals the judge's best guess. All right, a refreshing moment of judicial candor. So, all of that being said, to put this in perspective, under the law of evidence, what does the expert bring to the courtroom? All right? Under 702, the Federal Rules of Evidence, in most states, enlightened states that have model evidence codes, statutory codes, pretty much pattern this. Backward, asinine states like New York that have no code, even our case law models this. The point is, experts are there because of expert knowledge, scientific knowledge, technical knowledge, or specialized knowledge. Those are the parameters that justify the expert being in the courtroom. Expert-based knowledge. That's the only thing that justifies that expert's presence in the witness stand. So, what's the structure of the expert opinion that the expert is bringing? This applies to any kind of expert in any kind of case. Right? It's a logical structure, is it not? You have to have at least one major premise, you need at least one minor premise, and you have to have a conclusion. The key, in terms of what we're discussing, is the major premise. Right? Minor premise is just the case-specific information. Minor premise data, the case data. What you got in the interviews, what you got when you did the testing, what you got when you did the interactive sessions, and so forth. But you have to make sense out of all of that based on your expert knowledge. Right? That is what distinguishes an expert opinion from non-expert opinion. It's the major premise. Right? If it's anything else, it's not an expert opinion. Right? If it's common sense, I've heard evaluators, I've heard experts say, when cornered on cross, well, what's your empirical basis for making that statement, doctor? What research can you cite in support of that? Well, it's my common sense. Get out of town, all right? You're not on the witness stand because the law assumes you to have common sense superior to the fact finder. You're there because you have uncommon knowledge, your expert knowledge. Pseudoscience, junk science. This is really the most dangerous because it looks like a duck, it walks like a duck, it quacks like a duck, and it turns out to be a goddamn kangaroo when you get down to it. Right? But it has the aura of science, and that makes it especially dangerous. The Daubert decision, which is applicable in most jurisdictions, not New York, thank you. We're still in Fry, screwing around with one criterion, refusing to consider others. Right? But Daubert said, we give experts latitude on the stand that we deny to every other person on the witness stand, and the basis for that is our assumption that the conclusions that they're expressing have a reliable basis in the knowledge of the discipline. Not his knowledge, not her knowledge, the knowledge of his or her discipline. From our good friend, Dr. Martindale, in the year 2001, wonderful article, and he states it very succinctly. The defining attribute of an expert opinion relates to the procedures that were employed in formulating the opinion and the body of knowledge that forms the foundation upon which those procedures were developed. If the accumulated knowledge of the expert discipline was not utilized, then what you're getting is a personal opinion. It just happens at that moment to be coming from the mouth of someone who has professional credentials. But it doesn't make it admissible. Ignoring the boundaries of the research. Turning this around a bit. I often do workshops exclusively for mental health for psychologists who are getting ready for their AFib and so forth. And I tell the optimal way as an evaluator to ensure that your inferences and your conclusions will qualify as expert opinions is to base them on the research of the discipline and provide references in your report to the articles upon which you are basing your conclusions. That is the best way to make sure that what you're saying is predicated on the knowledge of your discipline and constitutes an expert opinion. Right? Another problem, commenting on issues outside the knowledge base of the discipline. Earlier, David said, somebody asked him before, these may be some of the most outrageous, but what are the most common? Well, here's one of the most common, is going places you just shouldn't be going, all right? One evaluator puts in the report, seems to me that the child support level is a little low here and really the dad should be made to pay more child support. Oh, really? Oh, really? From what course in your PhD training, doctor, did you derive that conclusion? All right? Or, I went to the home ground on one occasion, and there's a real problem with the electrical outlets there. All right, really, what course did you, Those things may be true. They may be based on good faith, common sense, and so forth, but they're not expert opinions coming from a psychologist. We wouldn't call an electrician to the stand and ask them to interpret a Rorschach now, would we? Using techniques, making statements that the research has not yet established to be reliable and valid, or even worse, using techniques and making statements that the research has already repudiated. Anatomical dolls as an instrument for determining whether or not the child is sexually abused and who did it. All right? The research has repudiated that as an assessment instrument to answer those particular questions. All right? The family bed issue. I have heard, let me ask you this, how many of you have heard expressed in the courtroom, in custody cases, an evaluator on the witness stand fault one or the other of the parents, usually it's the mom in my experience I hear being faulted, for allowing this 3 or 4-year-old to sleep in the family bed? That's bad parenting, bad outcomes. All right? Have you heard that? How many have heard something like that? All right? How many have heard it at all recently? Yeah, still hearing it. All right? In the first instance, it was said before the research was done. All right? Before the research has been done, and you're asked that question, there's only one proper answer to give, and it's 3 words, the 3 hardest little words ever. I don't know. All right? I don't know, Judge. My discipline has not yet formulated an answer to that question. There should be no embarrassment in that. But worse, it's now being given still testimony recently, you're saying, where you're hearing the same thing, even though the research has been done, and it does not result in negative developmental outcomes for children. I think it might be helpful to the evaluator to think in terms of your metaphorical library of psychology, where all of the knowledge of your discipline is stored and readily available, not uniquely to you, but to your profession. All right? And your job is to tell the court what's in the library. All right? What's in the library, and how does that expert knowledge from that library apply to the case before that particular judge? And I think if you visualize your task in that fashion, it helps you stay out of trouble. Cavalier and idiosyncratic approaches, ignoring guidelines and parameters. Very, very common. You want another one that's common? May not be as sexy as some of the other ones we're talking about. Here it is. All right? AFCC, APA, ACAP, they've all published parameters, guidelines, model standards. All right? In my judgment, the AFCC is absolutely the best thing out there. It's the most current, it's the most comprehensive, it has an interdisciplinary orientation, it's detailed. But whatever, pick one. Pick one, and when you pick it, stay with it. All right? If you're using idiosyncratic approaches, you may even be jeopardizing admissibility. All right? What do I mean by that? Dr. Smith is on the stand. I've had this occur many times. Dr. Smith, were you guided in your methodology by AFCC model standards? No. APA, no. ACAP, no. You go through the other ones that are not quite as significant as these. Doctor, did you, in formulating the methodology that you applied in this case, rely upon any published guideline, protocol, or practice parameter? Well, no. I used my own. You used your own. And is this something that you pick? They may say, I picked and chose. I took some from one, some from column A, some from column B. So in effect, Dr. Smith, you applied the Dr. Smith methodology. Is that correct? Yes. One question, Doctor. Have you ever published that methodology in the peer-reviewed literature of your profession? No. All right. One other question. If it's never been published, doctor, it's fair to say that it's never gained general acceptance within your professional community. Would that be correct? And in a Frye state, you have a very serious issue now with admissibility and striking of the testimony. And even in a Daubert state, general acceptance continues to be one of the criteria that a court may apply. Pick one. Don't go in there, seat of the pants, this is the way I do it. All right? Ignoring role boundaries. Another one that's very common and leads to some of the errors that we're going to mention here. The forensic role is different than any other role in psychology. All right? It's to investigate and report. Period. Okay? The evaluator's sole obligation is to investigate the case and report to the court. It is not to help the parents. It is not even to help the child, other than by meeting the obligations of the forensic role to report accurately, investigate thoroughly, and so forth. And I see time after time evaluators go off the rails because they want to help. They want to help. All right? Evaluator is not a therapist. Not a negotiator, not a mediator, not an arbitrator, and not a parenting coordinator, and not a junior judge. I say that because in one case, the doctor greeted the people at the first session of the evaluation by saying, "You're in my courtroom now." How's that for an examiner effect, all right? You're in my courtroom now. So, giving advice. Actual example from an actual case. The evaluation is underway. There have been a number of sessions, but it's not completed. And one day, mom has the kid wake up, and the kid says, "I'm not going to school," and pitches a massive fit. "I'm not going to school," and has a complete meltdown. Mom, not knowing any other mental health professional, called the evaluator and said, "So-and-so, my little boy won't go to school, he's melting down, you can hear him screaming in the background. What do I do?" And the evaluator says, "Well, let me talk to him." All right? And now she intervenes and talks to the kid and then talks to mom and says, "This is the way you should do it," etc., etc. Big problem. All right, big problem with that. It's outside the forensic role, number one. Number two, from this point on, the evaluator is now interpreting data of which she is a part. All right? She has changed the matrix. She is now part of that matrix. You know? She'll never know how mom might have resolved that in the absence of her advice. All right? It also has a possible biasing effect. Suppose mom said, "I don't think you know what you're talking about. I'm not going to do that." All right? That might have some biasing effect going forward. All right? Offering parents suggestions as to how to settle the case. You know, I'll tell you at the end of this evaluation before I do a report, this is my proposal. And if you don't go along with this proposal, then, you know, I file my report and the chips fall where they may. All right? Again, major problem. First of all, that's coercive. That's coercive. Those clients are sitting there, those litigants are saying, if I'm the one who says no, this doctor still has to write the report and I'll get crucified. Right? It's outside the role and it can distort the data. Possible biasing effect. One parent says, "Oh yeah, doctor, that's a wonderful proposal. You are just the smartest doctor I've ever known." And the other one says, "I think you're full of crap." All right? That might have an effect on the evaluator. Right? Hearsay reliance. 703. We don't have time to discuss it. This is a 2-hour discussion all by itself when we get into this. Hearsay reliance can threaten the admissibility of your report and your testimony if you make a mistake and rely upon the wrong kind of hearsay data. It can also affect the weight and reliability of your testimony, as was recently pointed out in a Court of Appeals decision in New York, which is our highest court. How screwed up is New York? What do we call our lowest court? The Supreme Court. And it can be reversed by 2 higher courts. Wonderful. But they point out that Relying on hearsay is a weakness, not a strength. It becomes a problem. All right, here's one from an actual case. Now, doctor, you've told the court in your report that Jill told you that Jack's ex-wife's aunt told her that Jack's ex-wife had told the aunt that Jack had once shot a gun in the marital residence, correct? All right? I mean, how many levels of hearsay are enough? And doctor, it's on the cross-examination. Doctor, did you go back and talk to Jack's ex-wife to at least bring us down to one level of hearsay? No. All right. Did you go and talk to the aunt to get us down to just a couple? Well, no. All right. Did you ever even ask Jack? He was right there in the interview. You had another session with him. Didn't you at least turn to him and say, hey, Jack, what's up with this? Did you shoot a gun in the house? No, Mom told me that was good enough. Right? You can't make it up. You can't make it up. Ignoring the appointment order. Right? Failure to abide by restrictions. Right? You have to read carefully each one in each case. All right? I've seen them where in one appointment order, the judge says, no psychological testing without further order of the court. I'm not saying you can't do it, doctor, but if you want to do it, you have to come back for permission. Never go back for permission, and they just did a battery of testing. Many judges today, or any significant enough number, put right in the appointment order, do not make a recommendation with respect to who should get custody. Give me a statement of risks and benefits based upon blah, 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 but don't give me that. And you see the report comes in, and they gave it anyway. And now the court has to say, do I strike the whole thing, assign a new evaluator, or do I play the mental gymnastic game and say, well, I'm striking it, and I'll pretend I never heard it. You know, that kind of game the law likes to play. You have to read everyone individually. They're not all cookie cutters anymore. The non sequitur, refusing to concede the obvious. Doctor recommended in favor of the father. All right. We had ample testimony in the case that Dad had alienated the kids, including tape-recorded evidence. Because I told the mom, when he starts up, because they were living in the same house, just have a tape recorder in your pocket, and when it starts up, turn it on. New York's the one party who said state it's perfectly legal. All right? We had a tape with the father calling the mother in effing C in front of the kids, and the kids chiming in unison with him, calling Mom in effing C. And the evaluator still came in favor of Dad. So I put the hypothetical. Doctor, assuming that you had known at the time that you did the evaluation that he had called her an effing C, and the kids called her an effing C, might that have affected your opinion? And instead of just saying, yes, it might have, right, he said, I'm not in the business of assuming things I don't need to know to be true. Oh, really? Well, let's go back to the other 47 paragraphs of your report. But the point is, the judge now gets mad at him because he's supposed to assume it. If you're asked to assume things, you have to assume them unless there's an objection sustained against the question. All right? So you finally I get him pinned down where he's going to answer. You know, would that be? He said, I can't answer it in that form. And so let me ask you this way. Would it be for a child to hear Dad call Mom an FXC? And you see what he's doing by fighting me. I've now gotten to say FXC 70 more times to the judge here. All right? And now the final, would it be, let's ask you this, doctor, would a child hearing the father call the mother that be a happy, healthy, and wonderful childhood experience? And so the answer was, it would depend on the circumstance. Okay, Doc, I'm going to go way out on a limb here. Name one. All right? So don't fight the process. If you're asked to assume the facts, assume that. If you're asked a yes or no, answer yes or no. Or I can't answer yes or no. Don't try to make speeches. In other words, don't be a wise ass. All right? And that's a term of art. You can look it up in the Black's Law Dictionary or in your APA definition or an APA dictionary, and the definition is slightly different in each, but the picture next to the definition will always be the same. Okay. You know him, you don't need to read the definition. Misusing text. Selection without reference. We're running close on time, but I just want to get to one last point here. Non-standard administration. The MMPI manual says you give it in a quiet setting, free of disruption. If you don't have ideal settings, maybe you use a waiting room, but you make sure it's a quiet waiting room without a lot of traffic. You don't want any distractions. And it says that right in the manual. All right? My dog doesn't bite. And if you remember, this I'm about to tell you is a final. Jeff and David and I, in competition with the Darwin Awards, we have our own "you can't make this shit up" competition. Okay? And what you're about to hear is a final. All right? Remember one of the Pink Panther movies? Clouseau goes in, an old Swiss innkeeper, and there's a dog there. And he says to the Swiss innkeeper, "Has your dog bite?" And the Swiss innkeeper says, "No." So Clouseau reaches down to pet the dog. And he almost loses his arm. So now Clouseau says, "I thought you said your dog does not bite." And the innkeeper says, "That is not my dog." A few years ago, Jeff and I are doing a seminar up in Rochester. We have mostly lawyers, but a few evaluators in the audience. And one of the lawyers at the question period says, I had a case where my guy was given the MMPI and the evaluator stuck him into a room where the evaluator had his vicious dog chained in the corner, snarling and frothing and so forth, you know? And our response was, yeah, that would be a problem. That could impact the reliability and the validity of the test outcome. But, you know, we hear stuff like that all the time. We take that with a grain of salt, right? Except at the break, that was the test. The evaluator comes up from the audience and says to Jeff and to me, he says, "That was my case. It was my dog, and he's not that vicious." So it actually happened. That's the MMPI. That's the MMPI in that particular case. You can't make this shit up, and that's what makes it such fun. Thank you.